Hi, everyone. Happy Friday. It is quite late. It is about to be 10 p.m. my time. We usually start these a little bit earlier, even if they're unplanned. But I didn't realize Cardi B had responded. So this is time-stamped 2 days ago, the 12th, 3:04 p.m. So I'm seeing it right now. And I posted it on X and I'm like, let's just go live. Let's just go live and talk about it because I really want to see Cardi B's response to Emani Ellis's motion for a new trial. If you missed that, I highly recommend at least checking out Amani's motion. If you want to watch it, when we went through a reading of it, the link is in the description of this video. It it was a time to read Emani Ellis's arguments for a new trial. We also took a look at Cardi B and her team's attempts to serve Emani Ellis's attorney because he's facing an order to show cause. He's got to answer to the court for some things that he's got going on. Um, and there were some interesting, we heard about a magician and signs, placards being moved, and it seems like possibly there's some evasion of service. Yeah, I highly recommend replaying that, but we're going to get all the updates. We're going to get caught up hopefully in about an hour's time, and we're going to get out of here. We're going to redirect to whoever else is live on this Friday night. And I do want to give a shout out to Ian Runkle. in in 4 hours from now, Ian Runkle will be going live for 24 hours. He'll be breaking it up between 4 different streams, but he'll be between those breaks, he'll really be live for 24 hours. This is his 6th year in a row raising money for the Stollery Children's Hospital through Extra Life. So, really great time. They raffle off gifts that his community members send in. That's how we got Hedgerico last year. You guys remember we named the hedgehog? So, usually hanging out up here out of sight, unfortunately, but always with us in spirit. So that is also linked in the description. And if nobody's live when we end this, I'll redirect you guys over to his first stream. So very, very excited to read this, you guys. Hey to Amy E, thank you for making sure to remind everyone to hit that like button. I think I'm cutting into Club Classy hours, but if they're still live, we'll go over there. FFS says good morning. Zariah says, hey. Hey, Big Dog Fluff, hope you're doing well. We've got Keontae in the building, Sheriff Chuck. This is going to be a good one if you have Sheriff Chuck in the building. Always good commentary. Kate says, I'm so excited to go through these filings with you all. See, this is why it's good to start at 10 p.m. because if you can't hang out during the day, we're glad you can make it to this one. So MLS doesn't like Cardi, but hey, she's not the wrongdoer here. And it's been interesting to see some of the Stan wars surrounding this case where people were having reactions that seemed very absent and separate from the facts of the case and what was presented at trial. But yeah, always good to see the different perspectives when they have some sound reasoning. Tally Pitlove's hanging out over on Twitch. Hey, Tally. Hey, Big Baby Jane. Long time, it feels like. Hope you're doing well. Danielle says, hey, 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 yay. Jimmy says, here we go. We're going to get into it. I promise. Red Bunny, also, it's been a minute here. So good to see you. Hope you're doing well as well. And M Loving Life. So let's get into it, you guys. Make this bigger for you guys. As a quick glance, what we're looking at as far as calendar scheduling, we already knew that there was a December 5th date scheduled for I guess we're going to look at contempt. I have a theory on what that might be for. We're supposed to be hearing about the order to show cause. That's going to be Emani Ellis's attorney that has to respond. And then we're also going to hear, I think maybe, this motion for a new trial. So we got a lot going on December 5th. We also have, before we get into the full filing, we have this minute order from November 6th. And we're just going to read it. Minute orders are nice and quick. Sometimes they're boring, but this one's good. So this was supposed to be a hearing on the ex parte application. So what that means is Cardi B's team had filed right to the court. You know, they didn't send the filing over to the other parties. And they were asking the court, hey, we've been trying to serve Ron Rosen-Janfaza. That's the attorney for Emani Ellis. Here's all of the attempts that we made. We have not been successful. We're either requesting that you deem him served or that you allow us to use alternative service. So that's what this hearing was about on November 6th. They call it to hearing, and guess what's noted here? There are no appearances by or for plaintiff's side, nor communication with the court as to why there are no appearances by counsel or parties this date. So, is there going to be another issue tacked on? You know, we already have Jonfaza facing an order to show cause. Are they also going to have to now answer why they failed to appear and failed to even communicate with the court for this? Like, we're just stacking on the layers here. So, who knows? But the court and counsel that were present, again, only for the defendant, for Cardi B, they confer, and the court decides, all right, we're going to deem service complete. So the request that Cardi B's team made was granted. And yeah, let's see. The ex parte application for order to show cause. Yeah, granted. There we go. Now we're going to get into the motion of the filing of the hour. It looks like it's long. It's 20 pages because they attach an exhibit, but it's not going to take that long, you guys. And I want to give a pause here. Sheriff Chuck, this is awesome, gifting 10 memberships. So let's get Sheriff Chuck in the banner real quick. Show Sheriff Chuck some love. He says it's 10 p.m. We're doing a live. We're going to give 10 gifts. So love it. Much appreciation here. And you are officially sponsoring this Friday night Cardi B party. And so what do we got? I did take a sneak peek, you guys. I read the conclusion. So I think we should do a spoiler alert and read this wonderful one-line conclusion to start. So you guys can feel like I feel when I start to read a motion before I go live. Because I want to read it raw with you guys. But I saw this. It says, conclusion. Plaintiff's motion, Emani Ellis's motion for new trial, does not withstand even cursory review and must be denied. That's it. Nice and short, one-liner. They said that's all we have to say. So let's look at their arguments. I just know it's going to be good. So introduction here. Plaintiff Emani Ellis's motion for new trial is entirely frivolous. She failed. I should make this bigger. There we go. So frivolous, F for frivolous. She fails to establish any permitted grounds for a new trial. Instead, she repeats her counsel's accusations of misconduct that are both false and not grounds for a new trial. And quick contextualization here, you guys. This is being worded in terms of Emani Ellis because that's just formality-wise. That's the way you write when you're addressing. It's the party responding to the party. But keep in mind that it's her attorneys that wrote what I think are nonsensical arguments, absurd arguments. So we're going to say she because we're appropriately addressing party to party. But really, these are all criticisms of the attorneys that are penning the arguments on her behalf. So instead, she repeats her counsel's accusations of misconduct that are both false and not grounds for a new trial. She complains that the court denied her request for judicial notice of the date of the 2018 NBA All-Star Game so that she could impeach defendants' supposed testimony that the game and the incident occurred the same day. Yet, as plaintiff's counsel is well aware, defendant never testified the game and the incident occurred on the same day. This is now at least the second time that, after the court rejected Mr. Rosenjonfaza's mischaracterization of defendant's testimony, Mr. Rosenjonfaza has persisted in falsely stating that defendant testified the incident took place on the same day as the game. So imagine this is your first paragraph, and you've got to underline and underscore that you're stuck responding to this. They have to respond. But they're like, Judge, you've already ruled on this. Why are they even still trying to argue this? But you got to put it pen to paper. So let's see. Finally, plaintiff argues that the two eyewitnesses to this incident should have been excluded, and without their testimony, the jury's verdict is not supported by the evidence. But plaintiff withheld their identity by falsely claiming they were unknown to her. Actually, this is the word, this is what it reads. Actually, shortly after the alleged incident in 2018, plaintiff tried to enlist one of them in plaintiff's and her counsel's scheme, including counsel in the scheme, to sue defendants even though it was plaintiff who attacked defendant. Further, the trial established plaintiff's multiple false statements, including plaintiff's false statements under oath. On the other hand, defendant was never impeached, not even once. That evidence is more than enough to support the jury's verdict, even without the two eyewitnesses' testimony. Plaintiff's motion for a new trial is properly rejected out of hand. Look, is this supposed to give us a visualization of a pa? Oh, man. Oh, this is going to be good. So let's break down these arguments, you guys. We've got one of our favorite attorneys in the building here. Always good in case we get stumped on something we don't understand. Uh, during reading Emani Ellis's motion for a new trial, there were things that stumped me. And I feel like the chat gave me some context on the details, like dates, things like that, that slipped my mind. But there were things that stumped me that really couldn't be cured by the addition of information. The argument was so absurd that I was like, am I missing something, or is this just not a good argument? So if we have those moments now that the opposing side, now that Cardi's side is replying, glad to have an attorney in the building to help me out if we need it. Oh, man. So plaintiff's motion for new trial should be denied. So A here, we have plaintiff's claim that defense counsel threatened to report her counsel to the state bar is both false and not a ground for a new trial. Plaintiff repeats her counsel's baseless accusation that defense counsel violated Rule of Professional Conduct 3.10 by threatening to report him to the state bar. Do you guys remember what attorney Janfaza, counsel for Emani Ellis, included as proof of this threat? If you guys remember, drop it in the chat. Plaintiff's memo in support of motion for new trial, shortened down now as plaintiff's memo. Not only is that accusation false, but Mr. Rosen Janfaza already has proven it false by providing defense counsel's August 4th, 2025 letter as Mr. Rosen Janfaza's claimed evidence of the supposed violation. We have two lawyers in the building. Two lawyers in the building to help us out if we get lost. That letter raises only that Mr. Rosen Janfaza's threatened press conference. So the answer in the chat, you guys, what I was looking for, Janfaza attached correspondence from Peter, from Cardi B's attorney, where Cardi B's attorney said something to the effect of, hey, you tried calling me to speak over the phone. As we've previously requested and instructed, all correspondence needs to be in writing. Also, you said over the phone that if we didn't come to a settlement, if we didn't settle this out, you're going to go to the press and do an interview. And it could be against code of conduct, what you're supposed to do as an attorney, if you go and have, extrajudicial statements, you say something to try to influence the outcome of these proceedings. So that was what Janfaza included, was a letter from Peter saying that. So he kind of like tattled on himself that contemporaneously an attorney felt the need to say, hey, you were threatening to go do this press conference inappropriately. So a little bit of stepping on a rake there. He says that letter raises only that Mr. Rosen Janfaza's threatened press conference before the trial would have violated Rule of Professional Conduct 3.6. And that rule reads that a lawyer who is participating in the litigation of a matter shall not make extrajudicial statements, an extrajudicial statement that the lawyer knows or reasonably should know will, 1, be disseminated by means of public communication, and 2, have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. So simply put, Mr. Rosen Janfaza tries to elevate a warning that holding a press conference on the eve of trial would violate the rules of professional conduct to a threat to report him to the state bar. And there is additional element that's relevant there too. It has to be, so an inappropriate threat, it needs to be an inappropriate threat with the intent of getting some type of benefit in response. So even if there was a threat to report someone to the state bar, Janfaza didn't allege the second element required for it to be an issue. So, further, defendant raised in her response to Mr. Rosen Janfaza's application for an order to show cause that 1, a violation of Rule 310 requires that the threat to report a person must be part of an attempt to obtain an advantage in a civil case. So there you go. So they're reciting, Cardi B has already pointed this out. And 2, Mr. Rosen Janfaza did not and could not claim that element of a Rule 310 violation was satisfied. Let's see. Forewarned of that additional defect in Mr. Rosengenfaza's false claim of a Rule 310 violation, plaintiff now adds a conclusory statement that, quote, the record establishes that defense counsel threatened plaintiff's counsel to obtain an advantage in a civil matter both before and during the trial. Oh, it's always a time. It's always a time. Yeah, Kate, if you did not see the motion for a new trial, I think that came down. Was it just last week or was it a week before that? It's like 10 days ago or so. And it was a wild ride getting through that. Like, this is doing a great job, in my opinion, of summarizing the absurdity of how that motion read. So it was a time. It was a time. And Laundered Amber, heck yeah, Friday night party with the chat. Heck yeah. GV's also co-signing. You've got to go and check out that Emani Ellis motion. If you don't want to watch with me, Pam Esquired also covered it. Love her. So big praise to her. She covered it as well if you want to check that out. Or if you just want to, if you already saw the memo but want to see her coverage, total vouch here for me for Pam Esquired. And there we go, you guys. Hey, Kimberly. So let's see. Where were we? We were here. Forewarned that an additional defect in Mr. Rosengenfaza's false claim of a Rule 310 violation, plaintiff now... Oh, wait, we read this part. Yeah, so they made this statement that the record establishes that this happened, that all elements were met. Yet plaintiff does not cite to any portion of, quote, the record, of the record. And we have parentheses. And for that matter, does not cite to anything at all. Oh my goodness. Oh, and we have a semicolon. So we have plaintiff does not cite to any portion of the record. We have a parenthetical that says, for that matter, does not cite to anything at all. And we have also, does not explain how warning him that Rule 3.6a prohibits his threatened press conference would supposedly obtain an advantage at trial, and does not even identify the supposed advantage. So just boom, 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 boom. Regardless, Mr. Rosengenfaza's false claim that he was threatened in violation of Rule 310 is not a ground for a new trial. And you guys remember, we were reading that, and that's one of the things I was dumbfounded about. Like, why is this in a motion for a new trial? It would be a little different if he said, look, this threat materialized in a manner that caused different actions to occur, and those actions impacted the trial outcome. But like, none of that argument was even made. I'm not saying an argument, if it was made, would be valid or a good argument, but the argument wasn't even made at all. So why was it, what was it doing? What was it doing in those memorandums? So, wait, we did this part, right? No. We read this first sentence. Not a ground for a new trial. He does not claim any such threats were made during the trial, let alone in the presence of the jury. He might argue that if he had not been, quote, threatened, he would have held a press conference before the trial and been able to taint the jury pool. Oh my gosh. Wow. Do you realize what this attorney is saying? He's saying, you know, the issue might just be that he wanted to do something improper. And because of the correspondence we sent to him pointing out that we would be aware that that would not be proper, and he's now forewarned that it would be improper, he can no longer do the thing he wanted to do with clean hands. That's a slick call out. And it's right. I think it's a correct call out. But he has no right to do so. Plaintiff's reference to the supposed Rule 310 violation is irrelevant to her motion for a new trial, and just another gratuitous attempt by Mr. Rosengenfaza to besmirch defense counsel and distract from the order directing Mr. Rosengenfaza. That is a mouthful. We need to... What were you guys were calling him? Ron? Mr. Ron, to show cause why he should not be held in contempt and sanctioned for his litigation misconduct. B. So B. Plaintiff's claim that defense counsel assaulted and battered her lawyer also is false and no ground for a new trial. So remember, we heard Ron say, They beat up, they assaulted defense counsel and one of our expert witnesses, but they had no affidavit from the expert witness that was supposedly feeling like they were assaulted and battered. It was just in the filing, they just made the assertion. Jeremy Rose also says, sorry, I can't stand Cardi B, but the girl suing her is ridiculous. You're not alone in this sentiment. MLS said the same thing. I'm sure there are plenty of people that feel the same way or don't care one way or the other, but they're looking at this because it's a major trial, interesting trial that now has ongoing, continued proceedings because of what seems like not great arguments for a new trial. So, Lakia also says this is wild. I can't help but agree. Sunshine's joining us. Good to have you here, Sunshine. Tarda Time's going to go back to the beginning. So when you catch up in real time, hey. And also says, thank you for the gifted membership the other day. So can't tell you who that was from, but big thank you guys always. Anyone that ever donates gifts, sends the gifts, tons of fun, always appreciate it. And Tarda Time Podcast is here saying thank you. And GV's giving the content. I love the chat. GV's saying, Ron assaulted opposing counsel in another case and stomped on his glasses. So is this just projection? Is this just projection? So let's get into the response from Cardi B's attorneys to that claim. So plaintiff asserts, Emani Ellis asserts that defense counsel, and again, I really feel like most of these assertions, her attorney, by signing off on this, is supposed to be representing her. So yes, this stuff is technically transferring to Emani Ellis. But I've got to wonder if she is really processing what he's arguing and if she's knowingly on board with what he's arguing. But then again, she decided to bring this lawsuit forward in the first place. So maybe they're both on the same page. It's hard for me to believe that two people on this earth could get there and be on that same page. I don't like to believe that, but let's be realistic. I guess it's possible. Plaintiff asserts that defense counsel, quote, physically intervened when plaintiff's counsel was speaking with Dr. Fink on August 27th, 2025 at the Alhambra courthouse, which amounted to an assault and battery. That conclusory assertion is repeated nearly verbatim and without elaboration in Mr. Rosengenfaz's declaration. Do you guys remember we kept trying? There were like two different declarations we had to read, and every other line, it was like, are they just going to repeat arguments from a motion, from the memorandum of law in support of whatever argument they want to make in a declaration? And it was blowing my mind, guys. If you missed that stream, if you don't usually read court filings, declarations are supposed to be where you provide your basis for having firsthand knowledge or like a good faith basis to believe because somebody told you and you're identifying how you're supposed to know certain information. And then the information that you provide in that sworn declaration is information that, for the purpose of a motion, the arguments made within a motion are going to rely on some information sworn to in a declaration. It is not for you to just say your argument twice and hope that the more you say something, the truer it becomes. But that's what's happening, and this attorney is calling it out here. So they made these assertions and they repeated it without elaboration in the declaration. Mr. Rosengenfaza provides no elaboration because his accusation is patently false. When he approached defense counsel and Dr. Fink in the hallway outside Department T, Dr. Fink said he did not want to speak with him, and defense counsel and then the sheriff's deputies told Mr. Rosengenfaza to walk away. There was no physical contact, no threats of physical contact, no yelling, and multiple sheriff's deputies were present at all times during the trial, both in the Department T and in the hallway outside Department T. Plaintiff now claims for the first time in her motion for new trial that, quote, the jury was present in the hallway waiting to enter the courtroom during this interaction. Once again, plaintiff repeats his conclusory assertion without elaboration in Mr. Rosengenfaza's declaration. For example, plaintiff does not identify any jurors who were supposedly present or how close they were. She does not provide any details because Mr. Rosengenfaza's story is complete fiction. But even assuming a juror was present during this interaction, he or she would have only seen Mr. Rosenjunfaza speaking with the defense team, Dr. Fink, and sheriff's deputies. Plaintiff also waived the issue by failing to timely raise it with the court before the jury deliberated, before the jury returned its verdict, and before they were discharged. Yeah, just 12 jurors sitting in a hallway, all crammed there. Nobody's gonna think that that's an issue. I mean, think about when we watch trials, you guys, and the jury is asked, did you bump into anyone in the hallway? You know, if you see someone in the elevator, it's one of the attorneys. Don't be offended if they don't start a conversation with you. They're just not supposed to speak with you guys. You guys are the jurors. Counsel comes in all the time and will say, hey, you know what? Just want to let you know, I did like walk by a juror when I was ordering food. Like these things, it's not weird to raise your hand, especially when an attorney is asking for judicial notice several times throughout a trial. You would think an attorney who has no issue raising an issue with the court would have raised this in a timely fashion, and they didn't. So that's curious. That is curious. So let's see. Finally, plaintiff further alleges in her motion for a new trial that this made-up physical interaction, quote, is not the only time that defense counsel has made contact with plaintiff's counsel against his wishes. And when we were reading that, it was confusing because it's like they started off making it seem like it was an issue because it was assault and battery against the Dr. Fink. But by the end of that section, it was like, it's not the only time you made unwanted contact with me. But that's not how you framed this argument initially. It wasn't an altercation with you. It kind of morphed into that as the argument proceeded. Yet again, plaintiff's conclusory assertion is repeated without elaboration in the declaration. Neither now nor in plaintiff's earlier filings has plaintiff or her counsel identified or described any claimed, quote, contact, stated when or where the contact supposedly occurred, or provided any other information whatsoever about any claimed contact. Further, plaintiff has not disputed that the only times that Junfaza, that Ron, and Mr. Anderson, so that's Cardi B's counsel, Pete Anderson, were ever at the same place at the same time was in Department T for the July 30th, 2025 final status conference, and in Department T in the hallway outside the department during the trial where they would have been witnesses. And notably, no court personnel, no jury members, and no sheriff's deputies who were present throughout the trial reported any contact between counsel, let alone an assault and battery. So plaintiff and Ron's unsupported and absurd conclusory assault and battery claims are properly rejected, and in any case were not timely raised and therefore were waived. Okay, wait, so we have context again from GV. GV is going bananas with the context in the chat. So let's see. So it was a medical malpractice case that led to the plaintiff suing the original attorney with Ron. The trial had gone on for 2 weeks when Ron got physical with the defense attorney. The defense attorney's glasses fell when Ron got his hands on him. Then Ron turned to the glasses on the floor and stomped them with his foot and broke them. Is this like projection is kind of like you accuse someone of doing something you do because you're paranoid, but is this maybe like a transference of memory? Like rather than just a projection to point a finger and say, nah, it wasn't me, it was you, haha. What if this is like legitimately him taking an experience and imagining it happening in another scenario and thinking it was the other way? Like just a figment of his imagination. Dang. And GV says witnesses were consistent that it was Ron, but he disagrees. The judge declared a mistrial and recused herself. Well, I guess that's one way to keep on with your client if that client kept him as an attorney. That's crazy, GV. Thank you for typing all of that out because that was interesting. Like, what are we doing? Next, we have plaintiff's claim that defendant allegedly threw objects at others outside the courthouse is hearsay, irrelevant, and barred by the order in limine. Plaintiff asserts that defendant, quote, threw a pen at a man outside the Alhambra courthouse on September 2nd, 2025. and that, quote, additional time was needed to determine whether a juror saw it. And remember, this was something that he wrote. So the pen thing was in September 2nd. And this issue where he's saying, I need more time to go figure out what actually happened, was in the filing that he submitted like less than, I think, like 10 days ago at this point. You had all this time. Why not go figure out the information if you're going to raise the issue? The plaintiff relies on the hearsay statements of her counsel that a pen was thrown, to which defendant objects, and just speculates that a juror might have been outside the courthouse, might have been in the group of press that gathered around defendant, and might have been swayed by the claimed tossing of a pen that hit no one. Further, the jury was instructed multiple times to consider only the evidence admitted during the trial. And I don't know, like, I think that it's subjective. Some people could say the pen was thrown in the direction of a person. Others say she threw it at the ground. Aside from that, though, Gianfranza said in his motion that there was like a second person that was injured from the pen. Like, so are we just like morphing this from what could be two people saying, all right, pen is out of hand and in motion? Is the intent for it to be thrown at somebody? Is it just an angry, like, puffing and throwing something to the ground? Is it a toss? Instead of just debating that, which would be a bit more reasonable, there was like a mystery second victim of this pen toss throwing that is, it's debatable if it was thrown at and hit the one reporter, let alone a second person. So like there was just like a random second victim of this pen thing inserted in Ron's arguments. So yeah, and I see Aaron and Sheriff Chuck just thinking of Kelly Deaver for no reason whatsoever. No reason whatsoever. Yeah. Aaron says, I personally witnessed the pen hit an ant on the sidewalk. Give me $1 million. Aaron, did you catch, there was a group, I don't know if it was like the Bronx Zoo or one of the bigger zoos across the country, but a group of people tried to sue on behalf of elephants and argue like in some philosophical way that they had standing. And it wasn't just like we have standing because we have ownership rights over the elephants. It was like philosophically because they're animals, but they're not humans themselves. We can just say that we feel for them and we have standing. And it was like this whole saga that went up through some of the Court of Appeals. I don't think it was Bronx Zoo. It was somewhere else. But it's reminding me of that because you're speaking on behalf of an ant and wanting to sue for $1 million on behalf of an ant. Unfortunately, that's not how standing works. All right, so what do we have? We have, let's see. Further, the jury was instructed multiple times to consider only the evidence admitted during the trial. If Mr. Rosengenfaza believed a juror might have been outside the courthouse and standing with the press, he could have asked that the court instruct them yet again to consider only the evidence admitted at trial. Or Mr. Rosengenfaza could have asked that the court question the jurors about what they saw or heard during the lunch break. He did neither, presumably because there was no reason to think any jurors were outside the courthouse at the time, let alone standing nearby. As for plaintiff's request for, quote, additional time, it is now more than 2 months later, and her counsel has done nothing to investigate. Plaintiff's counsel's speculation, knowingly false statements, and inaction are not grounds for a new trial. And it was weird because he made assertions that there's a second person that was hurt, but then also said he didn't have time to investigate. So where did you get the little bit of information that you're not verifying, you're not corroborating with anything, you're not giving detail to? Where did you get that information? Did you investigate or did you not? Because it seems like you didn't investigate and you're just making something up to make it sound serious. And not for nothing, but I remember Ron bringing this up in court. I don't remember the exact moment, but I swear he brought it up to the judge, and the judge was like, well, if the jury doesn't know about it, I'm not raising an issue. We've got plaintiff also asserts that in July 2023, defendant physically threw a microphone at a concert goer in Las Vegas. That assertion is also based on hearsay, and moreover, it is squarely within the court's order granting defendant's motion in limine, number 1, barring evidence and mentions of alleged prior bad acts. So again, this is the kind of thing when we were reading Emani Ellis's motion, there were several points in that motion where it was like, why would you poke and prod the judge with things that the judge has previously made a ruling on against you? You're disguising the issues that you have with the judge's ruling as if it's something new that the opposing party did that somehow now in retrospect, even though it's happening now or not at all, would have affected the jury back then. Like, why would you poke at the judge that way and act like you're not poking at the judge's orders? It goes on, it says, and during the court's questioning of the prospective jurors, they confirmed they had not heard any prior incidents or claims involving defendant. Once again, there's no ground for a new trial, and even if there were... All right, so we make fun of things when things are said twice, but this had to be intentional. Guys, this is how it reads. Once again, there is no ground for a new trial, and even if there were, parentheses, which there isn't, just 3 times laying it down that there is no ground for a new trial. Plaintiff waived it. Next, we have the court correctly denied plaintiff's request for judicial notice, including because defendant did not, in fact, testify that the NBA photo was taken the same day as the incident. Plaintiff argues that the court erred in denying her mid-trial request, and that it take notice that the 67th NBA All-Star Game took place on February 18th, 2018, and not, as plaintiff claims defendant testified, on February 24th, 2018. And you guys had to help me because I was like, I don't remember this. I don't remember this. Seems like plaintiff just made up that Cardi insisted it was a certain specific date or the same date. But plaintiff merely repeats her lawyer's knowingly false statements as to defendant's testimony. At trial, defendant's counsel, Ms. Moore, showed defendant a photograph of defendant at the 2018 NBA All-Star Game, and it refreshed her memory that the week she was in Los Angeles, her hair was blonde and she had short, squared nails. But plaintiff's counsel, and again, they're citing the transcript from the trial. But plaintiff's counsel later falsely claimed that defendant testified the photograph was taken the same day as both the alleged incident and the NBA All-Star Game, when instead the game was on a different day. The court agreed plaintiff's counsel misstated defendant's testimony. This is the thing. These arguments are like these arguments that Emani Ellis raised in her motion for a new trial are disputing things the judge has already made rulings on. And here in this response, Cardi's counsel is quoting the court telling the plaintiff that they were misstating the defendant's testimony. So this snippet reads from the court, I don't think that there was any representations of the date that was taken. She did just reference it generally, but the substance of the testimony was that she had those nails for the entire time that she was here. So whether it was taken on one day or a different day, I don't think that's material. So back to the motion or the response. Further, the court warned plaintiff's counsel that misstating the evidence in closing argument would constitute a knowing violation of the rules of professional conduct. But that did not stop him a few minutes later from falsely arguing to the jury that, and here's the quote, here's the transcript from Janfaza's closing argument. Mr. Rosen-Janfaza, the defendant testified that this photograph was taken on the date of the incident. Imagine Janfaza and Love trying a case on opposing sides. The poor judge in my hypothetical scenario. Back to the filing. And even now, despite having the reporter's transcript irrefutably establishing that defendant never emphasized, testified that the photograph was taken on the same day as the incident, Mr. Rosen-Janfaza yet again repeats the falsehood. Relying on that falsehood, plaintiff argues that the court committed an error of law. And I'm pretty sure he put that in a declaration that he signed on. So it's like in the declaration that he signs off on to also put as an argument in his motion for a new trial. So it's not just that he's like making an argument and basing it on something that's incorrect. He's also signing in a declaration that this incorrect thing is correct. This incorrect thing's correct. Yeah, like, what are we doing? What are we doing? GB says must feel good writing a motion where you can directly quote the judge several times. Like, oh, take it to trial. Good to see you. Says she should be done with this and just do a couple of interviews. I mean, honestly, there I think she could make good money. I think Emani Ellis could make good money doing a small tour, saying what she has to say. I don't even think she has to say anything that would get her in trouble. I don't think she needs to be spicy. I don't think she needs to cross any lines. Um, she could just say, you know, I still maintain my story. I don't it wasn't the outcome we wanted. But I learned a lot about the law. I know she had previously mentioned she's interested in getting into the legal world. I hope Junfaz is not her mentor if she goes that path. But like, I think she could make good money doing a couple interviews without putting herself at risk of saying something that's going to get her into hot water. I think that's a great idea. That would be much better than continuing with whatever is happening here because this isn't good. And again, even though I think a lot of this is the absurdity is really coming from her attorney, it's still he couldn't just file this without some degree of approval from her. So it's her too. Why? But good to see you. Hope you're doing well. Thanks for tuning in so late because I feel like you've probably had a long day. I think you were doing Devin Michaels, and were you also doing the Dima Tower trial? Or were you doing I don't remember what second trial you were covering, but I know you were doing like dual streams, two trial streams. So I know you've had a long day. You guys, make sure you check out Take It to Trial. And let me get a specific link, guys. If you're on Replay Crew, you've got to spell it all as one word with the number 2. Don't spell out the 2 because you will get the song Take It to Trial to come up as the top result. And then make sure you hit the subscribe button. That way you can properly pull up the correct channel. Great place if you're looking for a place to watch a trial stream, especially if you're not a fan of watching with law and crime. You'll have good choices over here. So that's linked in the chat. And again, on Replay Crew, you guys, Take It to Trial, one word with a 2 in the name instead of spelling out 2. Kate's yelling at me. Kate says, Kat, stop telling her how she can profit from all her and her lawyer's false claims. Look, if it lets someone move on. And again, like I said, she could keep it kind of neutral in these interviews. I mean, I wouldn't advise her to go out and start screaming specifics that are going to get Cardi B riled up. Cardi B said, look, I'm not going to sue you, but anybody else, just know I will start suing you for the things you say about me when you make false claims. So she shouldn't push that grace she was given. Because, I mean, it's not free, it's not cheap to sue somebody, but I think Cardi B might have the money to do that if she wanted to try. So why poke the bear? We've got back to this filing, you guys. All right, so we just finished up talking about the transcript. So court, during trial, when issue was raised, court's like, that's not how it was, that's not what the defendant testified to. I don't think this is material. Don't bring this up in your closing. Ron brings it up in closing anyway. Then, relying on that falsehood, plaintiff argues that the court committed an error of law by improperly denying her request for judicial notice that the photograph at the game was taken on the same day as the incident. But as the court stated, and Mr. Rosenjunfaza is fully aware, there was no testimony that it was. Mr. Rosenjunfaza's repeated and knowing false statements are not a basis for a new trial. While they do lend further support for the court's order directing him to show cause why he should not be held in contempt and sanctioned. Oh, this is great. Because again, you're doing all of this. This motion for a new trial was filed in the midst of there already being an order to show cause. So you are already undoubtedly, objectively in hot water with the court. The judge wants you to show cause. The judge wasn't saying, oh, you know what? The one party's asking me to consider going for sanctions against the other party or whatever. The judge themselves said, I need answers from Ron. What are you doing? And then he files this motion. What are we doing? Ultimately, however, the court has no obligation to take judicial notice of the date of the NBA All-Star game because the date is irrelevant. So defendant never testified it was the same day as the incident. Moreover, judicial notice does not extend to the truth of statements in the judicially noticed document. And then they're citing Ragland v. U.S. Bank National Association with it says, although the audit report is a government document, we may not judicially notice the truth of its contents. Accordingly, plaintiff's legal error argument also fails. I feel like sitting down to write the response to this, I feel like Peter just went cracked his knuckles and said, let's go, boys. Just got to it. Next, we have plaintiff's claim that the verdict is unsupported by the evidence is absurd. So, first section here, that even without the testimony of Miss Malcolm and Dr. Fink, the evidence would have mandated a defense verdict. In a backwards approach, plaintiff does not dispute that the verdict is supported by the evidence. Plaintiff instead argues that the evidence should not have included the testimony of the receptionist and doctor who intervened as plaintiff bore down on defendant in the hallway outside the doctor's office. Now, in what world, guys? Let's say we have not heard anything about this case. We didn't watch the trial, but there is an incident and we just have this sentence. This is the only sentence we know. Plaintiff argues that the evidence should not have included the testimony of the receptionist and doctor who intervened as plaintiff bore down on the defendant in the hallway outside the doctor's office. Intervened implies present physically. They're there. Not only are they in a position where they could observe something that's going on in their vicinity, but they're taking an action that makes them part of the action. Intervening necessarily means that you are now part of whatever's taking place. So imagine arguing, well, their testimony is not relevant. Shouldn't be included. You can't argue that. So what did the plaintiff try to argue? Well, it shouldn't come in because the defendant didn't identify these individuals for us. Right? So now we're moving outside the context of this sentence. What's the problem with that? Plaintiff did security at this building. Cardi B was there for an appointment, and it's not her normal doctor. She was there because she had some health concern while she was out and about. You work security there. How are you the one that can't go and figure out who somebody that was present for this altercation, this incident? How are you the one that can't go find out who they are? That alone, it just doesn't make sense. And it gets worse because of other things, but all of that just doesn't make sense. The next line starts with, one problem with plaintiff's argument is that even excluding the testimony of Tiara Malcolm and Dr. David Fink would still leave overwhelming evidence compelling the verdict for the defendant. And we've got this bullet point list. So for example, this isn't an exhaustive list. Defendant established at trial that plaintiff, after the alleged traumatic assault, supposedly scarring her for life, failed to seek medical treatment, failed to call the police, and instead went home and took a nap. I mean, plaintiff stated to, I wish I could sleep like that. Plaintiff stated to Dr. McKenzie, her psychologist in plaintiff's workers' compensation proceedings, that defendant, quote, almost touched her. Plaintiff stated in her all-important incident report to her employer that defendant supposedly cut plaintiff's nose, but plaintiff claimed in deposition at trial that defendant supposedly cut plaintiff's cheek. Plaintiff never mentioned any physical injury to her doctors at Kaiser, and quite the contrary, plaintiff confirmed to those doctors that she had no physical injury. Plaintiff, this is... Several of these would stand strong on their own without the other bullet points, but especially all together. Plaintiff stated in her incident report that she had her cell phone to her ear. She told Dr. McKenzie that she had her cell phone in her hand, but she testified on the first day of trial that she instead had an earpiece. Plaintiff's expert's own photograph of a claimed scar showed no scar. And to top it all off, plaintiff falsely stated in sworn discovery responses that defendant struck plaintiff about the head, face, and body. Oops. In stark contrast, defendant testified consistently, and she was never impeached. As a result, the evidence, even without the testimony of the doctor and his receptionist who witnessed plaintiff's assault on defendant, would obligate the court to toss a verdict for plaintiff, who obviously bore the burden of proof on her claims. So next, the court properly allowed the testimony of these two witnesses. So this whole section was just to say it's absurd. There's other evidence anyway. But instead, but in addition, we're going to argue here, we're going to respond, and the court made the proper ruling. Plaintiff argues that the court should have excluded the doctor and his receptionist who intervened in plaintiff's attack on defendant because she claims defendant, quote, intentionally hid their identity. And by supposedly doing so, quote, plaintiff was precluded from obtaining their depositions. Oh, there was more to that sentence. Plaintiff was precluded from obtaining their depositions early on to cross-examine them. This argument is entirely false, and the court properly allowed their testimony. There is no dispute that in responding to plaintiff's interrogatories, defendant specifically stated that the witnesses included two unknown persons who intervened during the incident. Plaintiff argues that Dr. Fink's identity was known to defendant since she booked a medical appointment with her doctor. But the trial evidence is undisputed that Dr. Fink was not defendant's regular doctor. Instead, while in Los Angeles for the NBA All-Star Game weekend in 2018, she randomly went to him for a quick check and did not recall his name years later when she responded to plaintiff's interrogatories. Because remember, this suit came like 5 years later, right? So this is not like, it's Cardi B that is the one that is suing Emani Ellis, and like Cardi B is the one that leaves the doctor's office, calls the police, says this woman cut me on the face with her fingernails, and starts immediately getting the information, getting the names. She went about her business. So why would you remember that 5 years later? And because she does not recall the doctor who briefly saw her, she also cannot, as plaintiff claims, contact his office to ask for his receptionist's name. It is also undisputed that defendant's counsel learned of the doctor's name by repeatedly going office to office in his building. So they tried. They made the effort when they had a reason to. Importantly, plaintiff knew all along. This is the issue. Plaintiff knew all along the identity of the doctor and his receptionist who intervened. Plaintiff was working as a security guard at the building. And shortly after the incident, plaintiff tried to enlist Miss Malcolm in plaintiff's scheme to sue defendant. It was plaintiff and Mr. Rosenjunfaza who concealed Miss Malcolm's and Dr. Fink's names by falsely stating in plaintiff's verified interrogatory responses, quote, employees of the doctor's office, unknown names. Tenants in the building, unknown names. Witnesses to the incident, unknown names. Let's look at this declaration. We're on page 9 right now. So this is what Emani Ellis and her counsel turned into the court. Even though they're now raising an issue, oh, those witnesses should have been excluded because we were precluded from interviewing them early on because defendant didn't identify them for us. This is how they wrote it in their responses to interrogatories. So employees of the doctor's office, unknown names. Tenants in the building, unknown names. Witnesses to the incident, unknown names. So if you're already the one that's identifying, you are saying that you want to be able, you could have put the names here. You worked there. You've spoken with these people. You've spoken with these people presumably more than once. You presumably know their names and what like office suites they worked at in the building because you did security there. If you had correspondence with them through text messages or other means, you probably had some way of finding out who they were, even if you didn't save their name in your phone. Like, how do you even make a representation that somehow Cardi B, the defendant, should be at fault for not identifying these people for you? So, and they square this off. I guess she writes it this way more than once. Yeah, so there you go. Unknown names every single time. I think that's it for that exhibit. Yep, so that's her submitting that. It's dated 8/9/2022. So we were here. Back to the response from Cardi's attorney. And despite knowing from the outset in 2018 that it was Miss Malcolm and Dr. Fink, plaintiff never took either of their depositions. Her reason for deposing them and for falsely claiming in discovery responses that she did not know their identities is clear. She knew they would repudiate plaintiff's story that defendant attacked her. Yeah, and maybe even say, and they tried to get me to go along with it. So that's a very good reason why somebody would want to be like, oh, we don't know who it was, but there were witnesses. We don't know who they were. They're unknown. Don't go looking for them. Oh, you went and looked for them? Next, accordingly, there's also no merit in plaintiff's claim that these witnesses should have been excluded. And then we get to my favorite thing that I saw as a sneak peek, the conclusion. One short sentence. Plaintiff's motion for new trial does not withstand even cursory review and must be denied. So there you go. This was filed 2 days ago. Didn't see it till like 10 minutes before we popped this stream on. Um, yeah, so we got Peter Anderson writing this. We got Eric Lamb. We got Daniel and McCurry, who did a hilarious. They put together all of the attempts to serve Janfaza. So that was a good read. We covered that in the last stream we got together for. It's linked in the description if you want to hear more about that. They found a magician, but they could not find the man of the hour, Janfaza. And Lisa Moore. Shout out to Lisa Moore here. Lisa Moore is the one we saw at trial, I believe, asking about the nail photos with the NBA All-Star game. And yeah, the chat went silent because I think some of the reason we're here, it just necessarily leaves us dumbfounded. Like, how are we here? Why are we doing this? Zindara says, because Peter wanted to say you and your lawyer is lying. And that's why I love reading these things, because I mean, I think this was professionally written, but you can tell that, like, in writing this, they're like, yeah, we're not going to hold back on some of the words that we're going to choose to use here. Sheriff Chuck says it has to be fun for an attorney to be able to write a reply knowing the motion has no chance, so they just take shots at the other attorney. Yeah, they just get like a freebie. Again, because like half of the points in here are just citing back to the judge's own words, the judge's previous ruling, the judge's explanation, the judge already addressing this thing that plaintiff is somehow raising as if it's a new and unaddressed issue, even though the court already has an opinion. So I think this is going to be great, guys. I would love if there's so much glamour and attention around Cardi B. She just had the baby too, right? I think I saw that, and I didn't go and verify, but I saw like TMZ posting that the baby was born. So if that's true, we're only a few weeks away. Not only is it Cardi B, but it's Cardi B that also just had a baby. And if she shows up in person to this hearing, and I don't know, I don't know if she has to show up, but I can imagine her showing up to just be like, like looking at Emani, like, why are we here? Are you serious? So I would love if there's actually a camera feed for this hearing. It shouldn't be that big of a deal. It shouldn't even be happening. This is just a hot mess for no reason. But I hope there's cameras in there. We'll watch it if that's the case. If not, we'll look for the minute orders and, the full order as it's typed out. We'll see what happens. Aaron and Jim both say it is fun. It is fun to do these, where was Sheriff Chuck's? Yeah, writing these replies. Yeah, Kate says at some point a judge or panel has to shut this down. I mean, what if the judge is like, and I'm going to report you to the bar? Like, you're raising an issue claiming that somebody's warning was a flat out claim that they were going to report you to the bar. What if the judge is just like, and as part of this, you've got to send notice. I'm sending notice. Yeah, honestly, Lakia, so I didn't follow leading up to the trial. I started watching the trial when it started. I had no experience with anything that happened before the trial. I didn't know anything, like GV filling me in on this stream, and I think the last stream, or maybe I saw GV over on Pam's live stream. Hearing just that little bit of context of stuff that's going on in other cases that he's a part of, it's just like really not a good look. So my opinion, I'm with you. I think we've got two clowns. I think we have two clowns. But yeah. So, Okay, and Jim says, I think in order to show cause re contempt would be more likely than a bar referral. But I think that's we were already at that we're here. We're gonna be there on the 5th. So and again, this was already scheduled, but are they also going to add on an additional contempt for failure to appear on November 6th at that hearing? So I don't know. You guys, we've gotten thank you again, Sheriff Chuck, for dropping these gifts in here. Super generous. Again, always appreciate your commentary. Thanks for also being so generous with the 10 gifts. And then GV, GV saying, hey, I've been here for 14 months. That's a really long time. So big thank you, GV. I'm going to take a quick peek and see who's live right now. If nobody's live, I will set up the raid just to go to Ian Runkle's stream, which is about 3 hours away now. He's going to be streaming for 24 hours to raise money for the Stollery Children's Hospital. We started our last stream, we started doing like a little bit of Christmas giving for teachers that have wish lists and need supplies or gifts for their kids. But instead of pinning one for this stream, focus all your attention on Runkle's 24 hours. And we'll get back to the regularly scheduled programming. Pinned Clear the List is what it's called for teachers looking for things that they need for their classroom for the holiday season. But for 24 hours. Not only can you help contribute to Stollery Children's Hospital and Ian Runkle's fundraising that he does every year, but you can also win a cool community contributed raffle item like this. Tons of cool prizes. So who's live right now? We've got well, let me refresh it. Trikesha, if you're still in here, Trikesha, is Flesh of the Gods actually still live? Or is YouTube lying to me? Let me pull that up because Flesh of the Gods was doing the Devin Michaels trial. Devin Michaels, the Las Vegas beheading, married to the stepson, and it was a lot. But she was found guilty of first-degree murder. It only took the jury 2 hours. Yeah, Jim says, "Oh man, I forgot that it's almost tomorrow. I can't believe that it's already about to be November 15th." Okay, yeah, so he is still live. What is he covering? What is he doing right now? Oh, everyone's saying good night in the chat, so we're not gonna don't go over there. But shout out to Flesh of the Gods. Love Flesh of the Gods, but he's shutting it down for the night. I think this is still just showing me who was live. Let's see if Classy's still live. Classy usually shuts down their song of the night. He is still live right now. He's on the ending screen. He's got an 8-minute stream is ending countdown. Let me go through my timeline. I see Lead Attorney's live. I have not seen Lead Attorney. I don't see Lead Attorney live all that much. He looks like he's still going. No one's in his chat saying bye. So let's go show some love to Lead Attorney. If you got, he's wound it down a little bit with content after he was taking care of his health. He does pop on from time to time. Let's go show Lead Attorney some love. We'll redirect over there and dropping the link one more time so you guys can get over to Runkle's stream in about 3 hours when that starts. And thank you guys for joining. Thank you guys for hanging out. Thanks for reading that with me. thanks for helping me with context or pointing out, I'm not crazy to feel like I'm a little bit lost. And we're going to get over to Lead. So go in there and say, hey, send him some good wishes. It's good to see him live. Hopefully see you there and see if you're up in 3 hours over on Ian's beginning of his 24-hour live stream. So you guys all have a good one. See you out there somewhere. Bye, guys.